Sorry, we have to restart because my table net went off and I changed to my hotspot from my phone. So I was making the point that we are discussing law of contract, and we are looking at the very first things which are discussed in law, the very first and which are discussed in the law of contracts. So formation. Yeah, sorry. Sorry about the confusion in the network connectivity. I think we will overcome that. So without wasting time, we start with the question 1. What reason is sometimes used to support the general test of the general objective test of intention in contract law? So A, one contracting party could not be certain that the other party has a clear understanding of the existence of the contract. So if you know the answer, just indicate it in the chat. Not that if you know, just try it. It doesn't matter if you are wrong, and we will get it sorted out. So the question we were looking at before the line went off was that what reasoning is sometimes used to support the general objective test of intention in contract law? And the options are A, one contracting party could not be certain that the other party has a clear understanding of the existence of the contract. B, the party's subjective. This is becoming a little bit irritating tonight with this internet problem. So B, the party's subjective intention may have changed from the time they negotiated the contract to the time the contract was entered into. C, each party will find it difficult to ascertain the subjective intention of the other party in the event of a dispute. D, all of the options given are correct. So which one do you think is the correct answer? Is it the case that you cannot see the screen? Please, can you confirm if you are seeing the screen or not? Are you seeing the screen that I'm sharing? We still don't see it. All right, thank you. So what is the answer? The question is asking us to tell what the rationale for the objective test of agreement is. What is the justification for it? Why does the law prefer the objective test to the subjective test? That is the import of the question. And we have given you a number of options for you to pick from. So let me look at some of the responses that you have. Okay, so we have B and C. Those who say that it is B, I would like to get the explanation. Then those who say that it's C, I would like to get the explanation. So please just put up your hand so that we can let you speak and we move fast. Yes. B and C, can you put up your hand and explain your answer? So that is more interactive. Can I see some hands up? Okay, so Nene B, okay. Yeah, Nene B, yeah, please explain your answer. You can unmute yourself, yeah. Please, you can unmute yourself.
Yeah, Doc, good evening.
Good evening.
Yeah, so I will go with C because I think subjectively, it will be very difficult for me to tell your reason or your intent of entering into the contract. But the reason for the objective test will be what the reasonable man or the ordinary man somewhere standing will construe per the terms, per the agreement, per the conduct of both parties, what the reasonable man somewhere will construe the meaning to be is what will suffice to be the objective test. So I think the reason behind objective test is not to get what you were thinking when you were entering into the contract, but what your conduct will be perceived to mean. And I think that's why I will go for C.
All right. Okay. Thank you. Let me take those who opted for B, and then I will comment on it, and then we'll settle on the right answer. B, can the B people put up their hand and explain the answer? Anybody who thinks that B is the correct answer? Any hand up? Also, the B, you have been convinced by the one who explained his answer for you to abandon your choice. Is that the case? Okay, if you've abandoned your answer, or let me see if you have any explanation in the chat. Okay, so Barrister said he has cancelled his choice of C because he didn't read well. Okay, I mean, that is fine. Thank you, Barrister, for your sincerity. Yeah. So, and again, let me come back to my favorite method to help anyone to juggle with a multiple choice question, what we call the elimination method. As we have said, by the elimination method, even if you are not 100% sure of the answer, you can use that to arrive at most of the correct answers. Sorry for this. I don't know why tonight the connectivity is misbehaving, but let's manage and keep doing it. Yeah, so let's start from the A. One contracting party cannot be certain that the other party has a clear understanding of the existence of the contract. Yeah, it looks a possible answer, but let's flag it and then let's move on. The party's subjective intention may have changed from the time they negotiated the contract to the time the contract was entered into. That, of course, it looks, but it's a bit unrealistic, isn't it? How can you know what is going on? Sorry about this connectivity problem again. Sometimes MTN is very unreliable, but there's nothing we can do. We just have to keep managing. Yeah, so I was just trying to say that we have to sometimes compare the answers. And if you compare the answers, you could see, okay, now we have D, right? That all the options given are correct. How about that? So A, is A correct or not correct? One contracting party could not be certain that the other party has a clear understanding of the existence of the contract. Yes, that is correct. That is correct. And then I'm not saying that that is the answer, but I'm just trying to say that it's a correct statement or a true statement in trying to explain why the objective test is preferred to the subjective test. And then let's look at the B. The party's subjective intention may have changed from the time they negotiated the contract to the time the contract was entered into. So subjective intention is like what one person or one party is thinking in his mind concerning what they are contracting about. But can we know what you are thinking in your mind so that if there has been changes, how can we tell? So on that note, B is just like A. What about C? Each party will find it difficult to ascertain the subjective intention of the other party in the event of a dispute, and that one too is correct. So I think that the correct answer is D, not C. So we have to be careful, right? Because the question, the answers like D say all of the options given are correct. And if you analyze A, B, C, they are all correct with respect to the justification for preferring the objective test of agreement to subjective test. Because you cannot tell me that the statement in option A is not true or is not correct. Neither can you tell me that the statement in option B is not correct or the statement in the option C is not correct. They are all correct. And if they are all correct, then the answer is D. And that is why when we are doing the multiple choice, we need to be careful so that we don't get it wrong. because like initially, somebody is saying that C is final. S, why are you insisting that C is final? Open your eyes and look at the, you want to know where the questions came from. No, I think where the question came from is not important. We don't need to know where the questions came from before we can learn, isn't it? Any question we come across, so long as it's relevant to the SAYS examinable areas, we can discuss it. So for me, that is not important. If you have any questions from anywhere and you want us to discuss it, I don't mind, so long as it relates to the subject areas which are going to be examined. There's nothing wrong if we discuss them. Yeah, so don't worry about the source of the question. That is not important. And what is important is what the questions are testing, as whether they are relevant to the examinable subject areas. If they are, then in my view, the source is not important. Even if any of you, you can form your own questions and you bring them for us to discuss them, I mean, no problem, so long as it provides the opportunity for us to revise, it's fine. So don't worry about the source, okay? Good. Then 2, the formal test of agreement is achieved through the concept of how do we establish the test of agreement. A, deed. B, parties conduct. C, promise. D, bargain. Yes. How do you determine whether an agreement has been reached? Of course, if you say a deed, if you say deed, that is fine, because talking about like the formal test, right? So pay attention, like so if deed is not there, right? If deed is not there, then you could go for other options like where the parties have reached like a bargain, D. And then if a bargain was not part of the answer, then you could just go for B, the parties conduct. But certainly, promise alone is not the test of agreement, because promise could just come from one side, and there must be a response before we can say that there's an agreement. That is why C is never the answer. 3, the outward expression of a common intention of the parties to a contract and of expectation normally takes the form of A, a promise, B, agreement, C, bargain, D, offer. So what is the correct answer to 3 in your view? 3. Yeah, okay, yeah, then I agree with those who say it's agreement. Yeah, so that is the outward expression of the common intention of the parties, where they have reached an agreement. And how do we determine that they've reached agreement? Where we have offer and acceptance, or where we can infer from the conduct of the parties that there will be some form of like a proposal or a promise or offer, and the other party has assented to it, either expressly or by conduct, as it were. Okay, how is the existence of a contract discerned by law? How does the law determine the existence of contract? A, by way of looking subjectively at the intention of the parties and their conduct prior to and at the time of entry into the contract. B, by way of applying objective tests based on a reasonable man test. C, by way of an objective evaluation based on a reasonable man test. But in answering this test, one looks at the circumstances surrounding the parties. D, all of the above. So this question is testing your knowledge about the objective test of agreement, and which of the options do we think is the correct rendition of that objective test of agreement, having regard to the options to question 4. Question 4, any thoughts? Yeah, any thought to question 4? Let me share the screen again. I think it went off again. Yeah, any thought to question 4? Yeah, let me look at the answer you put down. Josephine Anderson is saying that it's C. Let's look at the any other. You agree, C? C, by way of an objective evaluation based on a reasonable man test, but in answering this test, one looks at. I think that you are right that the C is the most accurate test, because if C was not there, then you could go for B, right? You could go for B, because in applying the objective test, we look at if there's an officious bystander present at the particular situation in which the parties find themselves, or in which they were negotiating or they were dealing. What would the reasonable man, that is the officious bystander, who have understood the parties as having agreed upon? And that is why C is a more preferred answer. So maybe you remember the cases of like the Smith and Hughes, Tamplin versus James, right? Especially like the Tamplin and James, where there was an auction of a house, and one gentleman who made the bid was so familiar with the house that he thought that an adjoining garden was also part of what was being offered for sale. So when he went to the auction room, he did not bother to read the brochure. And because he did not read the brochure, he didn't know that it was just the house minus the garden, which was being offered for sale. He made a bid, and later on he didn't want to pay, insisting that unless they gave him the garden and the house, he wasn't going to pay. The matter came to court. Doshinel was looking for specific performance, and the court granted it, saying that if you look at the circumstances, what would a reasonable person, what would an official bystander who have understood as being the subject matter of the agreement? Certainly, the house which had been described in the brochure, and the brochure which was present in the place of the auction, if you read it, you will know that it was just the house which has been mentioned in the brochure which was being offered for sale, and not any other thing. That is how the objective test works. Okay, now let's move. Let's come back to offer and acceptance. Just before we start, just a quick recap. You remember that an offer refers to a proposal or indication of willingness on the part of another person to enter into contract if the other party will accept it. And we know that the other party must make unqualified assent to that proposal, and that's what we call like the acceptance. We know that already. So let's look at the question 1 and the offer and acceptance. Which of the following could give rise to a unilateral contract? I hope you remember unilateral contract as opposed to bilateral contract. Before we look at the question, can anybody tell us what a unilateral contract is and what a bilateral contract is? Don't answer the question yet. We just want to understand the concept before we apply it to the question. What is a unilateral contract and a bilateral contract? Anybody? Just put up your hand and then speak. Let's be quick, please, so that you can go to bed and the internet also will stop worrying us. What is a unilateral contract? What is a bilateral contract? These are things, don't let us waste time, but I want to get your input so that it will enrich the discussion. And all the time, it's only barrister who volunteers to speak. The rest, you're not generous with your contribution. Okay, so let me give the opportunity to Manuela, and then after that, we come to barrister. Because barrister is well known in this house. He contributes all the time, okay? And then need to, and so a regular contributor. Yes, Manuela. Yes, you can mute yourself. Emmanuel?
Okay, thank you very much. Simply, a unilateral contract is where one makes a promise for the actual performance of something for the other person. With the bilateral, it's a promise for a promise. So the whole contract is based on a promise. The offeree makes a promise, and then the offeror makes a promise, and the offeree in turn also makes a promise to do something. That is for the bilateral. But with the unilateral, offeree makes a promise for the offeror makes a promise for the offeree actually perform something for him. So that's when we have Carlill and Carbolic smoke ball for the unilateral contract. Sorry.
All right, thank you, Emmanuel. I think that is, so let me take another person. So, okay, Barrister, your hand was up for, yes. Barrister, yes.
Thank you. What I recall about the two is that in the case of bilateral contract, as the name implies, there's a promise or an offer, and then perhaps some acceptance, or there's a kind of exchange of promises between the two parties. And in this case, the offeror makes a promise to the offeree, and the offeree also have to respond, or maybe by way of acceptance, by communicating the acceptance. But in the case of a unilateral offer, one party actually makes the promise. It's some kind of, it is onerous. And then the other person does not necessarily need to, or the offeree does not need to communicate his or her acceptance by any way. The mere performance of the act of the
Yeah, I mean, Barrister,
offer.
that is fine. What I don't like about your explanation is the onerous, which you added. That is what I don't agree, but all the other things.
All right. Yeah, thank you, Doc.
So now, Ni Namuli, yes.
Unilateral contract is a contract with the whole world. Acceptance is by performance, and bilateral contract is between two or more people who have there's an offer and the other person accepts.
Okay, all right, that's fine. Finally, let me take Ibn. Yes. Ibn, do you still want to speak? Yeah, you can mute yourself. Yeah. Oh, no. Ibn, yeah, you can mute yourself. Your hand is up. Yes.
Hello, sir.
Yes.
Hello, sir.
Yeah, Ibn, go ahead.
Unilateral contract is formed where a promisor makes a promise in exchange for the actual performance of an act by the promisee, as opposed to a counter promise. Whereas bilateral contract is formed when one party makes a promise in exchange for a return promise. In this case, the contract consists of two promises which depend on each other.
Okay, all right. So I think you're all right. So fundamentally, unilateral contract, there is only one promise, and that promise requires an act to be performed. And because there's only one promise, acceptance of that promise is by performance, carrying out the required act. And as Emanuela rightly mentioned, the case of a Carlill against Carbolic smoke ball, Aaron Clark, and so on, Fitch and Senedeka, Williams and Kawadin. Yeah, and then bilateral contract, as you rightly said, bilateral means two. So we have a set of two promises. One promise to make something available, the other promise to take that, and so on. So two promises, and for that matter, but of course, the fact that there's two promises doesn't mean that one is making a counter promise. So don't use that word. Because if you say like a counter promise, then we are going to the realm of a counter offer. If you remember the case of what is the case? Counter offer, the well-known case, hide and range. Yeah, so that isn't what we are talking about. Okay, thank you. So let's come back to the question itself. Which of the following could give rise to a unilateral contract? A, in return for B, promising to run a marathon, A will sponsor B 500 Ghana cedis. B, in return for B completing a marathon, A will sponsor B 500 Ghana cedis. C, both of the options given are correct. D, none of the options given is correct. What is the correct answer to question 1 and over and acceptance? Okay, one David has said D is correct. S has also said that B is correct. So now we have 2 competing answers, B and D. Now let's analyze them to pick the correct answer. In return for B promising to run a marathon. So that is a promise by an A will sponsor B 500 Ghana cedis. Now, if we look at A is suggesting that there are 2 promises, because that in return for B promising to run a marathon. So, and then A will promise to provide, or A will provide a sponsorship. So we have to flag A as being problematic in terms of unilateral contract, because from the way that it is, it suggests that there are 2 promises, and that will make it the bilateral. But let's move on. B, in return for B completing a marathon, A will sponsor B 500 Ghana cedis. So in B, we see just 1 promise, and the promise is by A that I will give 500 Ghana cedis if you complete the marathon. So all that is required of B is to complete the marathon. It doesn't need to promise to do it, as it were. But if we look at the answers given, the answers given are problematic. I don't know if you see the problem. Do you see the problem? Okay, David. David.
Yes, if I could come in.
Yes.
So generally, when you're looking at a unilateral contract, there is a caveat there that you are making a promise to the world. Most of the time, the offer is to the world, to the general public. Anyone who does it will get the prize. So where the other party is known, that means you've excluded that world aspect, because unilateral, you're looking at, is supposed to capture anyone who does it should get the prize, as we saw in Carbolic and the smoke ball. So that if anyone performs it, he should get the prize. So if the other party is known, a specific party is known, then that means that you are trying to go, like you said, bilateral. So that's why I would say none of them is correct, because they all capture 2 individuals, one to another, one to another. But it doesn't give you the general option that is supposed to capture a worldwide view, that the general public, that anyone who does is supposed to get a prize.
Okay, David, thanks for your explanation, but let's take Bex, and then I will comment on, Bex.
Yeah, Doc, good evening. Please, I also think that from the answers, it doesn't really mean that A knows B or B knows A. It's more like saying in the B answer, in return for maybe Carbolic, Carlill completing the use of the smoke ball, you'll be given this for whatever, like you'll be given this amount of money, or he'll be given this. So I don't really think it necessarily means that B knows A and A knows B, but it's just the way they have put it. So I would still think that B will be the answer.
B will be the answer. Mm-hmm. Okay, now since there is no any other hand up, let us come back to the discussion. So from David, okay, there's a McDonald would like to speak. Okay, McDonald. Yes, McDonald, you can unmute yourself. McDonald, go ahead. Good evening, McDonald. I think your line.
The question
Yes, go ahead.
I asked myself in these two was one, as to whether which of them would be a unilateral. Yes, but I'm saying that with the two, I asked myself as to what would be about which of them would be a bilateral offer and which of them would be a unilateral offer. Then I realized that the A would be a unilateral offer, because if return for B, I'm promising to run a marathon, A would sponsor B. It means that it is a general of is a unilateral offer that has been made. And in respect to the second one, I'm saying that it's a bilateral offer because specifically I can be able to identify who. Hello, Doc.
Yes, I'm listening.
Yes, I'm saying that with the second, I will be able to identify who the offeror and then the offeree is. So I will say that with the second one, if B becomes the offeree and A becomes the offeror, this is the understanding I'm having before I can be able to. So based on that, I will say that A is the answer.
Right. I've heard. Okay, let's take Francis and Nana Jamfi, and then we'll conclude. Francis, John, and Yaba. Yes, you can mute yourself.
Yes. Sir, I don't know whether mine is a clarification or a question. In the definition of unilateral contracts, at least I had two people, including David, most recently, say that unilateral contracts are contracts that, aside from the correct definition they give, they add the fact that a requirement of unilateral contracts is that it is made, a unilateral offer or contract is that it made to the offer is made, is necessarily supposed to be made to the entire world. At least I don't remember it like that. And I don't know if you clarified that, because I know that we have general offers and we have unilateral contracts. I think the essential thing that I remember at least is that unilateral contracts are contracts, as has been explained, in exchange, promise in exchange for performance. There would only be a contract after the conduct is performed, not for exchange of promise. But then I know general offers are the ones that are usually made to the general public. And of course, the same Carlill and Carbolic case applies. But unilateral offers do not have that specification. It doesn't necessarily have to be made to the general world. It can be made to an individual as long as it is a promise for a conduct. I don't know if it's a clarification or so.
Okay, so I'm happy. This is what I want us to have in this our discussions. We need to get clarity, as far as the concept is concerned. So once you understand the concept well, any question around it, you can answer it. So we take the last one and then I will clarify it. Yes, Nana Jamfi, please go ahead.
Okay, thank you, thank you, Doc. Let's consider the A, for instance. Assuming that B is unable to complete the marathon, assuming it starts, but also is unable to complete the marathon, does it qualify for the sponsor of 500 cedis? And then if you take the B, it's only upon the condition that B completes the marathon. That's the only time that he qualifies for the sponsorship. And so in order to secure the parts, I think the concept should be that, or is that until the marathon is completed, does it qualify for the sponsorship? And so I'll go for B rather.
Go for
just in line with the case of the Carbolic small ball case, where there was a specification that the small ball ought to be used in a particular way to merit the price. So I'll go for B rather.
Okay, so let's take the last one and then we will we'll conclude on it. Hey, we have to. Okay, the last two. Nenebe. Okay, Nenebe is gone. So let's take Samuel. Samuel, we are the last one, and then we conclude on this particular matter and then we move on. Samuel, say one, so please unmute yourself. Samuel, unmute yourself. Or is your hand up by mistake? Okay. Yeah, Samuel, unmute yourself. Samuel, yeah, unmute yourself.
Okay, sir, good evening.
Good evening.
Okay, I think my understanding is whereby there is a scenario that somebody is saying that I will pay anyone maybe 100 cedis if you find my dog. I think that one is a unilateral offer. But another thing I also understand is whereby someone say that do this for me. If you are able to do it, I am going to give you 100 Ghana cedis. So I think that one is a bilateral offer. So the emphasis here is on the promise,
okay,
whether it is going to be accepted or not.
All right, thank you very much. Before we resolve it, while you are making your contribution, I have consulted three sources, so we are going to use that to resolve it. We start from Black's Law Dictionary, right? So Black's Law Dictionary, the 11th edition, page 411, unilateral contract. So listen, a contract in which only one party makes a promise or undertakes performance. So that is it. Only one party makes a promise or undertakes performance. Then they will cite Atiyah, Introduction to Law of Contract, and say that Atiyah explains it as follows. Many unilateral contracts are in reality gratuitous promises, enforced for good reason with no element of bargain. Then he explains, if A says to B, if you walk across Brooklyn Bridge, I will pay you $100. A has made a promise, but has not asked B for a return promise. So follow that. Now, let's move on. A has asked B to perform, not a commitment to perform. A has thus made an offer looking to a unilateral contract. B cannot accept this offer by promising to walk the bridge. B must accept it, if at all, by performing the act, because no return promise is requested. At no point is B bound to perform. If B does perform, a contract involving two parties is created, but the contract is classified as unilateral because only one party is ever under an obligation. So the takeaway from the explanation of unilateral contract in Black's Law Dictionary is that when the promise is made by the promisor has no business to expect that the promisee or whoever is going to follow it will actually do that which has been promised or not. So because there's no commitment on the other party to say that I will do it or not do it. All that is required is that if you really want to take the benefit of the promise, he must do that which is required by the promisor. So let's keep that in mind. And we're going to use that understanding to evaluate the options that we have. And then we have our answer. And again, those who have been relying on the Carlill and Carbolic smooth ball, if we look at JPOL, right? If you look at the JPOL, they shed important light on the issue. And this is what they say, that Carlill and Carbolic smooth ball has been valuable in explaining unilateral contracts. A unilateral contract is a contract whereby the offeror makes a promise. So in this case, to pay £100, that's the Carlill and Carbolic smooth ball, in return for performance of a stipulated act. Mrs. Carlill makes no promise and can decide not to continue her use of the smooth ball at any time. because the promise was that you have to use the smoke ball for 2 weeks, but there was no obligation that you must necessarily do that. You only do that if you want to take advantage of the promised reward, the 100 pounds, as it were. And then the authors, they go on to say that, to summarize, there are a number of exceptional rules which apply to unilateral contracts for which Carlill and Carbolic smoke ball is authority. A, whereas the general rule is that an advertisement is an invitation to treat, that is invitation to make an offer. If the advertisement requests the performance of an act, then the advertisement will be an offer. I mean, that is fine. There's no dispute about that. Whereas a general rule is that an acceptance must be communicated to the offeror. The offeror may impliedly waive this requirement and will take in have done so when the offer is unilateral, unless there has been an express indication of the fact that notification is requirement. That is also obvious. And then, yeah, so going by this understanding, let's look at the answer. In return for B promising to run a marathon, A will sponsor B 500 Ghana cedis. So based upon the understanding we have, A is obviously out. It's not the correct answer. Or who will dispute that? So we have ruled out A. Now B, in return for B completing a marathon, A will sponsor B 500 Ghana cedis. If you look at B, if you examine B carefully, B appears to suggest that A will, so A say that I will sponsor 500 Ghana cedis if you complete a marathon. So for B, do we see that A has any expectation that B will consider himself bound? No. Because what it means is that if B does not complete the marathon, A will not provide the sponsorship. Or but how it is catch, right? How it is catch, there's still a problem because B appears to look like an example, like a past consideration. Like in return for completing a marathon, A will sponsor. So like the marathon have been completed already, and A is promising to provide the sponsorship. But that is not how unilateral contract is. Unilateral contract, there must be the promise, and the promise is stipulating the required acts. But if you look at B, it does not appear to suggest properly that A has stipulated the required act. It's like a certain situation has come into existence, and in response to that, A is making a promise. And if that is so, then the answer will be D, that none of the options given is correct. Yeah, so that, okay, S has raised up his or her hand. Yes, S, go ahead.
Sir, my dispute with us selecting D as the answer is that when you look at B, it says in return for B completing a marathon, A will sponsor 500 cedis. Now, my understanding is A has made a unilateral contract in the sense that he has made an offer to somebody, the first in time to perform, and that if the person completes a marathon, he will sponsor him 500 cedis. So my emphasis is on the word in return. That is, if the person happens to complete it, then he will sponsor. But if the person does not, then he's not obliged to sponsor. And so I still think that the answer should be B. That's my argument.
Okay, so you understand that in return for completing a marathon as not necessarily the fact that B has completed the marathon already, and then A is promising to provide the sponsorship. Okay, so if that is the understanding of the expression, right, the English construction, then you are right. But on the other hand, if you're understanding it to mean that the B has completed a marathon, and then in response to that, A is promising that you sponsor B, then we'll go for D. But what is important at this stage is that we have clarity in our mind that by unilateral contract, it's not really the case. You know, some of you were trying to also overstate the principle. Some of you were saying that you cannot have a unilateral contract unless you've made like the promise to the whole world. Not necessarily. If I tell you that if there okay, if you find my missing phone, I'll give you 10 cedis. Or anyone who find my missing, I'll give you 10 cedis. It may well be that you are the only person who is there, but you are the one that I'm talking to. I don't expect you to promise me that I'm going to look for the missing phone and then you give me the money. All that I'm interested in is that you bring the phone and then you're entitled to what I have promised. Okay, so let's move on. 2, in which of the following situation will B be entitled to the reward given in the offer of the contract on completion of the required act? A, B reads a poster on a lamp post offering a reward of 50 cedis for finding a lost cat. A lost cat, which is called Lucky. B later finds the cat and returns it to the owner. B finds a lost dog and takes it to a pet rescue center. The dog is subsequently reunited with its owner. B later finds an advertisement in the newspaper of 100 Ghana cedis reward for the return of the dog. C, B finds a lost dog and takes it to the police. B expects a reward from the owner for finding the dog. The dog is then returned to the owner. 1 week later, B finds out that the owner had sent flyers around the neighborhood offering 75 Ghana cedis reward for finding the dog. D, all of the options given will entitle B to the reward. So which one do you think is the correct answer? We are still in the area of unilateral. Yeah, so let me look at your answers. Ninebe has gone for A. Obey has also gone for A. S has also go for A. Okay. Okay, so let's look at A. B reads a poster on a lamppost offering a reward of 50 Ghana cedis for finding a lost cat, Lucky. B later finds the cat and returns it to the owner. Okay, so you are right because the B was aware of the, not only aware, is aware and is also done the required act. And that is the classic situation of a unilateral offer. Or has anybody got like a contrary explanation? Because if you look at the B, yes, if you are, well, if you look at the, the authorities are divided, I must say, when it comes to unilateral offer, especially accepting it in ignorance of the promise and reward. And if we look at the B, what is happening is that B had done the required act before he became aware of the promise reward. And is he entitled to it? Yes, some authority says that insofar as you have done the required act, it does not matter that you were ignorant of it when you did it. You're entitled to it. And C, B finds a lost dog and takes it to the police. B expects a reward from the owner for finding. The dog is then returned to the owner. 1 week later, B finds out that the owner had sent flyers. So C and B are in the same category. The B performed the required act at the time that he did not know about the existence of the promised rewards. But as I said, the authorities who says that you are entitled to the promised reward. And if that is so, then the answer will be D, meaning that B is correct, C is correct, and A is correct. It's not only A which is correct, because there are authorities which says that even if you you perform the required act and you are not aware of it, you should be entitled. You look at the Fitch and Senedeke, of course, the Williams and Kawadan and Gibbons and Proctor, those line of cases. Okay, Francis, you want to make a point?
Oh, sorry. I think I raised I wanted to make a point earlier. When we're construing, yes, for the word completing. I wanted to add to, yeah.
No problem. So Bex, you want to talk, Bex?
Yeah, Doc.
Yes.
Please, the question 1 and 2.
Yes.
Has made me a little bit confused because it appears that sometimes the subjective view of the examiner will count.
Right.
So when you have questions like question 1 and 2, how would you know that the examiner is expecting you to think this way and choose this answer? Because from what you are saying, if the examiner is thinking that for the question 1, the B is past consideration, then the answer B will be wrong. And in the question 2, if we are looking at the other views where, for instance, the police, there was an offer later that I think a policeman saw it later but had performed the act and all those things. If we are bringing all those exceptions to it, then it means that D is the answer. How would we be able to know that we should think this way or should think that way?
Yeah, so I share your difficulty, especially, and that is why it's one of the reasons why I don't like multiple choice for law, but we cannot do anything about it, especially where we have what they call like the conflicting authorities. Because if you take, if we take like the book I'm holding now, Jelfu, they will make the point that they will just support that where you are not aware of the reward, you cannot get it. So for example, look at what they say at page 14. There are other legal principles applicable to unilateral on which it is convenient to consider at this point. A, it is possible to accept a unilateral offer of a reward only if you know that it has been made and accept in response to it. So decide the case of R and Clark. R and Clark is an Australian authority, a case from Australia. This means that the act, which is the purported acceptance, cannot have been performed before any promise of a reward was made. So that is the position represented by R and Clark. But as I indicated, we also have other to suggest that where you have done the required acts, so long as you've done the required acts, you are entitled to the promised reward. If not for those authorities, then certainly the most correct answer is A, because that is where you are aware of the promised reward and you have done the required act. That is the standard or the conventional approach. And that is consistent with the R and Clark. Of course, you also have other authority which says that if you are aware of the promised reward, but you did it out of some other motivation, it doesn't matter. You are still entitled to the reward. Remember the Williams and Kawadan, the woman who said that she needed to ease her conscience, having witnessed the murder and all that. Yeah, so I appreciate your concern. I think Ni, you want to say something?
No.
Yes.
All along that we have been taught at the faculty, we knew that you must know the offer before you perform and before you get the reward. That's why there was a past question based on Gibbons and Proctor.
Okay.
But being aware of the offer. So today I'm a little bit confused in the sense that I don't know of the other authorities, the textbooks that I've been reading, that you can, once you perform, you will get a reward. Because if you look at that of Clark, and if you look at Gibbons and Proctor, and then cowardice in somebody,
yes,
I think you must know of the offer. This is what we have been taught, and this is what I read in textbooks, even modern textbooks.
Right.
Thank you.
Okay. I think that what I said is, if you read cases like the U.S. case of Fitch and Senedeka, that possibility is suggested. But of course, we often follow the what they call the UK and the general common law jurisdiction. Not to say that the US is not the common law jurisdiction, but as we know, the US, they have what they call that the restatement of the law of contract, the uniform code, and all that. So their principles are somewhat a bit more standardized, but we still follow the traditional English common law or the traditional English case law. But as I said, R and Clark is stated as the main authority for the position that you must be aware of the offer before you can accept it. And also Gibbons and Proctor. And then Williams and Cowardan will say that if you were aware, but there were some other consideration, it doesn't matter. You are still entitled to it. Yeah, so on that basis, you are right. But Fitch against Senedeka, as I said, is an old New York decision from the US, decided in the 1868, which suggests that that possibility is also there. Yeah. Okay. Yeah, somebody's hand is up. If it's the same thing, then I think that let's move on. Otherwise, you never. Yes, Bex, is your hand up again? Beck, is your hand up again?
No, sir, please, sorry.
Okay. Let's move on. So 4, no, I did not. No, I think the 3. In which of the following situation will the court most likely prevent A from revoking the offer of a unilateral contract? A promises to pay B an extra 500 cedis on top of the 5,000 B has received from other sponsors. If B completes a walk of the Chivalry Hills, B sets off on the walk. A telephones B to tell B that he revokes the offer. B, A promises B to pay 1,000 Ghana cedis if B can change the specification of his car such that the car can complete a lap of a race course in 5 minutes. A revoked his offer during the lap. C, A promises to pay B 500 Ghana cedis if B locates a rare gemstone in the Himalayas, but A states that he may need to revoke the offer at a later time. A revokes the offer just as B arrives at the foot of the mountains. D, A promises B to double the amount he's willing to sponsor B for running a marathon if B raises a level of sponsorship, which A deems impressive. After B has raised 1,500, A state is unwilling to keep to the agreement. So the question is asking us to pick which of the 4 options would the court most likely prevent A from revoking the offer of unilateral contract. So first of all, what is the principle regarding revocation of offer in unilateral contract? So let's get the principle stated first before we apply it to the options. Okay, so 2 hands are up. Francis, what is the principle?
My hand, I want to make a comment on the question 2. That's why initially I didn't want to make a comment, but then I think somebody brought up this thing. I want to add up. I think she was making the comment as to the subjective construction of the sentence, and I wanted to point out that, at least in my understanding, whether you construct the completing in the past continuous or in the future continuous, one thing we should know is that the question is not talking about unilateral offer, but a unilateral contract. So even if it was in the past, as in the act has been done in return, would be done. He's now saying he will give it after. So I think the deed that you chose and the deed is still correct, regardless of the construction, because it's a unilateral contract. So the conduct has to be done after to constitute a contract, not just the fact that the offer has been made.
Okay. All right. Thank you, Francis. So let's come back to 3. I want a statement of the principle regarding revocation of unilateral offer or offer unilateral contract. What is the principle of law? Yes. Barrister, you want to state it?
Well, I want to say one of the principles is that for unilateral contract, once the performer has commenced, the court may not allow the offeror to revoke the offer. The mere fact that the offeree has commenced performance is sufficient. Thank you.
Okay, and do you have any authority to buttress that? Any case law? Any case law to support that? Okay, he's gone. Okay, is it, who spoke? Was it Barrister or Ninebe? Okay, Ninebe. So let's take Ninebe, you want, have you had your turn or not yet? Okay, then let's allow yes, and then me. Yes.
Sir, please. In the case of Shui versus USA,
yes,
it states that in order to revoke a unilateral contract, you are supposed to revoke it in the same manner in which the offer was made. So that is, if you made it by advertisement, you are supposed to revoke it by advertisement. Thank you, sir.
All right, thank you. And then, all right, and further to that, once you have used that, it doesn't matter whether the offeree became aware of the revocation or did not become aware of the revocation. The most important thing is that you use the same channel in which the offer was communicated. Now, as for authority as to whether you can, somebody said that you cannot revoke or have performance as commenced, and there was no mention of authority. Remember the case of Errington and Errington, which supports that as well. So now let's come back to the options. The options to pick the correct answer, having known the legal principle. So what is the correct answer? Let me look at what you put over there. Question 3. David has gone for B. Let's see. A promises to pay B an extra 500 Ghana cedis on top of 5,000 cedis B has received from other sponsors. If B completes a walk of the hills, before B sets off on the walk, A telephones B to tell B that he revokes the offer. So is that permissible? Is that the permissible way of revoking an offer in unilateral contracts? Yes, S.
Sir, that particular answer did not specifically state the mode through which the promise was made. However, it is my assumption that it was done through a phone call because he called to revoke. Thank you.
Okay, and then I also wanted you to add the Errington and Errington aspects. that so long as performance has not commenced, you can revoke. And if you look at the A, before B set off on the work, meaning that performance has not commenced. So technically, nothing prevents B from revoking this unilateral offer. And it's consistent with Arrington and Arrington line of authority. So A is out. So let's come back to B. A promises B to pay B 1,000 Ghana cedis if B can change the specification of his car such that the car can complete a lap of a race course in 5 minutes. A revoke his offer during the lap. So here there is a performance has commenced, and we know that we cannot revoke where performance has commenced. So A is a good candidate for correct answer, but let's look at C as well. Henry Oda, you want to say something? Your hand is up. Henry. Henry Oda. Yeah, you can mute yourself. Your hand is up. Yeah, you want to say something? Or it was an accident? Okay. C, A promises to pay B 500 if B locates a rare gemstone in Himalayas, but A states that he may need to revoke the offer at a later time. A revokes the offer just as B arrives at the foot of the mountain. So if you look at the C, yes, Henry, your hand has been up, yes. Henry, you are allowed to, yes.
I wanted to speak when you were done with all the four.
Oh, no, I mean, now we are just trying to.
Okay, all right. Then
already
for the B.
A is not an answer, but the B
okay.
flag as a possible answer, but you want to validate it by.
Yes, the B, I was wondering from the way that the sentence is structured, can we tell whether B has actually made specifications to the car, like the answer is saying?
Okay.
I don't know if you can tell from the way it's structured whether he has actually done anything.
That condition stated. Okay.
Yes.
All right. Okay. Right. Right. So it has to do with like the construction. But anyway, but let's look at the C and the D, and then we will conclude on that. So the D, we are told that when he made the offer, he indicated that he may need to revoke the offer at a later time. Then he revokes the offer just as B arrives at the foot of the mountain. So C, performance has commenced, but we cannot say that no, A is B is different from C, because the C, you are supposed to find the gem in the Himalayas. The fact that you have arrived at the foot of the mountain is no assurance that you go ahead and actually find it. And for that matter, A is entitled to disregard you and go ahead with this decision to revoke, in my view. So let's look at D. A promises B to double the amount he's willing to sponsor B for running a marathon if B raises a level of sponsorship which A deems impressive. After B has raised 1,500, A state is unwilling to keep to the agreement. Yeah, D2, there's a lot of room for the promisor to get away with it, because there's some subjective aspect of the offer if he deems impressive. So if he thinks that 1,500 is not impressive, you cannot blame him. And for that matter, I think that despite the fact that B does not let us know whether the changes to the specification of the car have actually been made, I think that it appears to be like the most likely answer. And for that matter, we could settle on B. Yes, S, you want to say something?
Yes, sir. Sir, looking at B, right?
Yeah.
And contrasting it with A. I'm sorry, sir, you've moved up. If you could come down a bit on. Yes, sir. All right. It says A promises B to pay B 1,000 Ghana cedis if B can change the specifications of his car such that the car can complete a lap of a race course within 5 minutes. So performance is required in two parts. That A, he makes certain specifications to the car, and B, that those specifications will enable the car to complete at least a lap. So even if he has done some specifications, he hasn't totally or fully performed the obligation. But when you look at A, it says that A promises to pay B an extra 500 on top of 5,000 B has received from other sponsors if B completes a walk of the Cheviot Hills. Before B sets off on the walk, A telephones B to tell him that he has revoked the offer. Now, sir, here it is evident and clear that he has in no way started performance, and so the offer can be revoked. But with B, there's a dispute as to whether the offer can really be revoked because he has begun the first part of the requirement. So I still argue that A is the answer. Thank you very much, sir.
Oh, you think A is the answer? You see, the A will fly in the face of Errington and Errington, isn't it? Because performance has commenced. Or you don't think that performance has not commenced. Performance has not commenced. And the question is that in which of the following situation will the court most likely prevent A? In other words, will it be impermissible for the unilateral offer to be revoked? And Errington indicates that where performance has a commenced, you cannot revoke. But if you look at A, performance has not commenced. And because performance has not commenced, as it were, there's nothing preventing the offeror from revoking it. But I think that we can continue to debate this, but let's move on. What is important for me, as I keep saying, is not we picking the correct answer, but we being clear in our mind as to the correct principles and how to analyze the various questions or issues which we get. So that is fine. So let's quickly move on. In Carlill and Carbolic smoke ball, which factors led the court to the conclusion that unilateral contract had been formed? A, Mrs. Carlill used the ball for 2 weeks as requested in the advertisement. B, advertisement stated that £1,000 have been deposited with the bank. C, the offer was made to the public. D, all of the options given are correct. This is a very straightforward question. It requires that you know the case of Carlill and Carbolic's smoke ball. So what is the answer? Oh, sorry. No, this thing has changed. I don't know why. Yeah, okay. So what is the answer to question 4? Let me look at your answers. D. Okay. So yeah, I mean, if you are familiar with the Carlill and Carbolic smoke ball, yes, the two using the ball for 2 weeks is part of what made the court say that is actually the offer. Then it said that they had deposited 1,000 to show seriousness of the intention. C, that the offer was made to the public. And D, all the options given are correct. Is somebody giving a different answer? Let's look at the Nineveh is going for A. The Mrs. Carlill used the ball for 2 weeks as requested in the advertisement. Okay. You notice that a number of points were argued in that case. But let's say that unilateral of what is unilateral contract? That you promise a certain reward or payment for a stated act. And what was the promise reward? That will pay you if you use the ball for 2 ways, as we have indicated. So that certainly is the contract. Now, Ulu said that if the company, if there was this argument that it was just a mere path, and then the court said that it's not a mere path because they said they had demonstrated the sincerity of their intention by setting money aside with the bank in London, out of which those who be entitled to the promise 100 will be given. Then the offer was made to the public. Is that what really made the court to say that it is a unilateral contract? Certainly not, because I think we could say that, the question said that which factors, so please sometimes pay attention. The question said that which factors led the court to the conclusion, and all the things that we have in A, B, C, they all played a role in the decision of the court. And for that matter, it will be correct to go for D instead of just settling on A. Yeah, so that is why D is the correct answer rather than A, as Mr. Zinenebe or who went for that? Somebody also said that because I see the offer was made to the public. No, all the things stated there, if you read the case, they all played a role in the conclusion of the court. Because a number of objections were raised by the company that how can we say that we've made an offer to the world and all that? It's not possible. This was a mere path and all that. And then the court said that no, yes, you indicated that the ball should be purchased and used according to prescribed manner. And if a certain outcome happened, then the victim or the person who used it was entitled to a promised reward. Yes, Ni, you want to comment?
Yeah, Prof, sorry, number 3, what did you say the answer is?
Number 3.
3.
Number 3, we settle on the just ask B arrive. No, the race. Where do they have like the race? B.
B.
B, yes.
Okay. Then what about Luxor and Cooper? The case of Luxor and Cooper.
Okay.
Where performance started and yet the court did not agree.
No, but no, yes, but if you look at and that is what the question is saying, that where would the court mostly prevent A from revoking the offer? Now, where you have started, where the other party has started performance, then you cannot revoke. And that is what the question is asking for. And if you look at the B, we are saying that performance was ongoing, although there has been some debates regarding whether the other required performance in terms of changing the specification of the car has taken place or has not taken place. But looking at how the construction is, we could assume that insofar as we are told that the lap, right, the lap was ongoing, or the racing was ongoing, we can assume that the other things have been taken care of. Yes.
Okay.
And for that matter, if you compare with the other options, I think the B appears to be like the most suitable answer. Yeah. And that is why we settled for B.
Okay, thank you.
All right. Yeah, so I think so let's go to 5. In which of the following situation will communication of an assessment likely be required? A college writes to 8,500 students, offering them one-to-one tuition with the famous professor if any of them get a mark above 80% in their mock examination. B, a circuit writes in the newspaper that it will provide a reward to the first 10 people who inform the circuit that they have access to a 3-legged animal. C, a circuit states in one of its flyers that it will provide free entry to anyone who turns up dressed as a clone. And D, all the options given will require communication of an acceptance. Okay, now we know the requirement of the rules on acceptance with respect to unilateral offer and bilateral offer. So aware of those principles. Which of these options given Olu say that there's a need for communication of acceptance? Henry. Henry, yes. Henry, you are allowed to speak. Okay, Henry is not talking. You can mute yourself. And let me even release all of you. If we want to speak, just speak, but make sure that only one person is speaking at a time. And then when we are not speaking, then you just have to mute your mic, okay? Because you are not many, so we can discipline ourselves in that respect. So let's do it this way. So you can unmute yourself, okay? If you have to talk, you can mute yourself. Yes, Henry? Your hand is up, you can mute yourself. Otherwise, okay, let me put your hand down. It appears a mistake. Yes. Yeah, Tony, you want to speak?
Hello, sir.
Yeah, Tony, go ahead.
No, sir, this is Henry.
Oh, sorry, Henry. Okay, go ahead.
I wanted to ask about question 4 before we moved on. Yes, I wanted to ask when we were dealing with C.
Yes.
That's the offer being made to the public.
Yes.
In the Carlill case, was that a basis for them coming to the conclusion that was a unilateral contract? I thought that had more to do with the general offer part.
Yes, but it is also indisputable that a common characteristic, although is not a sine qua non, is that a unilateral offer is made to the public. It's also a common characteristic. So in that respect, we can also say that it's part of the ratio.
So unilateral contracts are always made to the public?
Not always, but as I said, it's quite common, right? It's quite common.
Okay.
If you read test writers or authorities. For example, I'll not go for just to cite one of our own Marcel Ofoku-Agyemang's book, which I have in mind, just listening to a little bit of it. Example of unilateral offers are advertisement offers made to the world. Carlill and Carbolic small, but that's what he cited. Lost and found advertisement with promises of reward attached. This offer also classifies as an offer to the world at large, was typical of the type in the manufacturer's offer to pay compensation to users of their products if the product does not live up to expectation. Often such offers are part of a general publicity campaign popularizing the products, and still citing Carlill and Carbolic's book again. Yeah, so I think that it is right to say that all those factors in one way or the other exercise the mind of the court in agreeing that what had been advertised was something leading to unilateral contract. Now I think that 5, all right, 5, nobody seems to be ready to answer, provide answer for 5. We know that for unilateral offer, there's no need for communication of acceptance. Acceptance is by doing. Bilateral offer require communication of acceptance. So for the options given, you need to find out which ones are unilateral offer. The one which are unilateral offer, you just cross them out as not requiring communication of acceptance. Then the one which you think is a bilateral offer. Nenebe, please go ahead.
So I think there is the B. And I think it's the B because if you look at the A says that they are ready to, they wrote to the students and are ready to offer one-on-one tuition with anybody who gets or who performs a specific act of getting 80% mark in the exams.
Okay.
So that one is a no-no.
Okay.
Then we go to the C. He said a circus states in one of its flyers that it will provide free entry to anybody who dressed up. So that one too is a promise for a specific performance. That one too doesn't require any communication. So that one too is struck out. The C is struck out.
Okay.
Then the D also says that all of the above, no, that one they will not even go there. So the B, let's focus on the B. Why I went for the B? A circus writes in a newspaper that it will provide a reward to the 10 people who will inform. So in a way, they are even soliciting for a communication of acceptance, who will inform the newspaper that it will provide. So what they are trying to say is that if you know you have this and this with you, you can also accept our offer and we do business. And that is why I went for B.
Yeah, all right. I think I agree that you are. Yes, Nenebe, your hand is up. Or you're the one who spoke?
Yeah, I just spoke.
Oh, right. Yeah, I think your analysis is right. So, and I like how you applied the elimination method in answering multiple choice question. Now you try to cross out the most unlikely answer. And then, yeah, of course, so D can never be correct because some of the options does not require communication of acceptance. So D is out. So once D is out, then you started from the A. A, if we look at it, is satisfy the usual appearance of a unilateral offer. So that one is out because we know that doesn't require communication of acceptance. Okay, then you come to the C. C also meets the typical nature of the unilateral offer because like a particular act is stipulated to be done and then you're entitled to the promised reward. So once you're able to cross out the ones which are not likely, you will definitely be left with one, and that will be the correct answer. As even if you're not sure about it, the elimination would help you to arrive at the correct answer, as it were. Mark, you are Zuri. Yeah, you can unmute yourself. Mark, you are Zuri. You can unmute yourself. Your hand is.
Yes, sir. Can you hear me, please?
Yes.
I have a problem with choosing B as the right answer in this case.
Right.
I thought that it would have been A.
Okay.
In that even if you get over 80% in the class,
yes,
you can still opt to be taught by the professor or not. And so you still have to accept that offer. Getting 80% in the exam by the professor, you still have to accept the offer from the school because the wording of A itself alone shows that it is an offer. I think in B, in the case of B, it's a unilateral offer. All you have to do is to inform them that you, what is the option?
B, mean the, yeah.
Yes. That you know somebody who has a three-legged animal or something. You don't need to accept that offer. All you have to do is to perform.
Right. Okay, we will not waste time in debating 5 further. as I keep saying, the principle is what is important now. The principle which is important for this question is that for unilateral offer or an offer unilateral contract, there's no requirement for communication for acceptance. Acceptance is by doing. So all that we have to find out is that which of the options given is unilateral acceptance, and then the one which is a bilateral, unilateral contract, the one which is a bilateral contract, then there's a requirement for communication of acceptance. So I think that is a principle which is important. So I think that enough about this unilateral offer and then bilateral offer. Let's move on to question 7. Question 7. Yes, David, question 7. Which of the following are essentials of a valid simple contract? A, offer and acceptance only. B, offer, acceptance and consideration only. C, offer, acceptance and privity, certainty and duress only. D, offer, acceptance and consideration, intention to create legal relation and certainty of terms. I think this is a very straightforward, and I expect everybody to get it correct. So put your answers in the chat, and then I will just put your answers in the chat. Everybody, I hope everybody will get it correct. This is very straightforward. Okay, yeah, I think that is it. Is D. Yeah, so a simple contract, also known as a parole contract, requires offer, acceptance, and consideration, intention to create legal relation, and certainty of terms. So that is pretty straightforward. Now, under Ghanaian law, a promise to keep an offer open for acceptance for a specified period of time is not binding on the offeror in absence of consideration. True or false?
False.
Now, what is the authority? What is the authority?
Section.
Now, can I talk?
Section 8.1.
Yes.
Yes. Section 8.1. Section 8.1 of Act 25.
Which says that.
Yeah, promise to keep. The promise to keep an offer open for a specified period of time is binding on the offeror, although there was no consideration thereof.
All right, thank you. So that is very good. Now, in one of the following cases, it was held that for communication by instantaneous or near instantaneous, the contract becomes complete only when acceptance is actually communicated to the to or received by the offeror. A, Adams and Linsell. B, Carlill against Carbolic Smoothball Company. C, Entos Limited against the Malfires Corporation. And D, Iden Wrench. Write your answer and then yes, write your answer in the chat. Write your answer in the chat. Okay, some have written, a number have written C, and one person has written A. Okay, I think this is a straightforward. Adams and Linsell, you know that I laid down like the postal rule, isn't it? Yeah, yes. But once you have sent, once you have written the acceptance and then you are posting it in the usual way, acceptance is deemed to have taken effect from the moment that you posted, and not when it got to the recipient, the offeror. That is the Adams and Linsell. And then Carlill and Carbolic Smoothball, we've just been discussing it. It has to, in terms of acceptance, its relevance relate to acceptance of unilateral offer, which does not require communication, and it only requires performance. So that one is out. Then Entos Limited against Malfires Corporation. Of course, that is the locus classicus in which the court made the point that the postal rule does not apply to instantaneous mode of communication. No, and over there, what was the mode or the medium was like the tellers, and the court said that the other party, that is the offeror, must actually receive, must actually hear the fact of the communication of acceptance before same will be considered to have taken place. Of course, hide and wrench does not come in at all, because hide and wrench has to do with the counter offer, isn't it? Where an offer has been made to you, instead of accepting it, if you make another offer, then that is a counter offer and is considered as a rejection of the original offer. 10, a qualified acceptance operates as a rejection of an offer. Which case best explain this principle? Please write your answers. Write your answers. Let me see how far we have to. Oh, sorry. I think we cannot finish. We just have to end. This is getting late to go to work tomorrow. Yes, write your answer with respect to that was the question number 10. A qualified acceptance operates as a rejection of an offer. Which case best explains this principle? Broadway Metropolitan Railway, 4th year in Zano, DB against Nsia, Dominic's Fisheries Limited as in Bremen, Vegas Fisheries. What principle was decided in Broadway against Metropolitan Railway? Anybody? Broadway against Metropolitan Railway, what principle?
Acceptance by conduct.
Yes, who? Yes, Nenebe.
Acceptance by conduct.
Acceptance by conduct. Okay. David. David.
Hey. Yeah.
Okay, then 4th year and Zano, what principle was decided? Jamfi, Nana Jamfi.
I think it's the Battle of Forms.
Battle of Forms?
Yeah.
Can you explain in what respect?
It's about the party who gives the last shot. Let's say if documents go back and forth, so the last document has the claim or the say.
Hello, sir.
Yes. Nenebe.
So I think it has to do with acceptance, and it was the court was of the view that there must be a positive evidence that you used words writing or you made acceptance by a conduct.
Okay. Okay. What about Debe against Nsia?
Counter offer.
What happened in Debe and Nsia?
Say if I may.
Yes. Is it S or
Yes, sir.
S? Okay.
If I remember clearly, in DB versus a solicitor was staying in, I think, a house or an apartment, which was sold to somebody else. And in his defense or in his suit, he said that he was first made the offer to purchase and he accepted, but he was asking for, I think, a reduction in price, and the court said that a qualified acceptance is invalid, and so I think that is the principle in that case.
Okay.
Thank you.
All right, and then Dominic's Fisheries Limited against Bremen. S. S, can you tell us what? Yes. Dominic's Fisheries.
Sir, if I may.
All right, David.
Okay, so in Domains Fisheries, the principle that was established by the court is that a request for information concerning a contract does not constitute counteroffer. In that particular case, they requested if there would be a moratorium because they had already agreed to buy a ship, and then per the agreement, they were supposed to there was another agreement aside the initial agreement, so that they will pay in installment. So per that new agreement, they requested if there could be a moratorium before they start paying in installment. And then the other party construed that request to mean a counteroffer, and the court said that is not a counteroffer.
Okay, so let's come back to the question, which case best explain the principle that a qualified acceptance operates as a rejection of an offer? C. Yes, S, your hand is up. You want to say something different from what we were discussing?
Oh, sorry, sir. I mistakenly left it on after making a submission. Thank you.
Thank you. Okay, so you go to work tomorrow. So we would like to draw the curtain down tonight and we continue another time. So have a very good night.
Thank you, sir.
Sir, thank you very much. God bless you.
Thank you very much.